like to mention two items, my lord. One, item 48 of daily list, and the other one, item 50 of supply list, my lord. Can it be on Monday, my lord? 48 and 50, my lord.
And
50, my lord. Supply list 50.
on the pyramid, this transfer.
First month, 1st of September. Obligation.
May I please look? My lord, I have to mention for upgrade, my lord, item number 35, my lord. Only for consideration of bail, my lord. 35. Yes, ma'am. Obligation.
Very pleasant also. So I have to mention item number 26, London Council P. Halder is out of station, man. So it will become after 1 week, and another item is 31, my lord. It will be common after 1 week.
26.
26 and 31.
After
Obligation.
and item
31. Obligation.
Your Lordship, I beg to mention item number 70. In this matter, there are some typographical errors, so I may be allowed to rectify the same, and the matter may be come up next week, Your Lordship.
where is the error?
Error is in synopsis and the pair part and some of the translation part.
Your name?
Item 7.
Your name?
R. Karim.
Mr. R. Karim, Learned Counsel to the petition, submits that there are certain typographical errors in the synopsis statements and in the translated copy of the annexures. Accordingly, it's prompted to make necessary corrections in the same. They'll be done before the EUGFT section. Thereafter, the matter will be.
Published.
May I please, Your Lordship. That's why I beg to mention item number 29, Lordship. Lordship, conducting council assets Sigdar, Lordship, out of station today. And this apparently, I don't know. There is an interim order, Lordship. It may be complete.
Okay, 2 weeks. Is the interim order limited interim order?
My lord.
Don't know.
No, interim orders are not limited, not up to the next date here. Lordship.
Yes. Next.
Bless.
May it please your lordship. In item 32, lordship, we have filed an IA for implement of the detainee as a petitioner, my lord. The same may be taken together.
Trial protocol and the council for the petitioner submits that an interlocutory application has been filed for
Implement of the detainee, my lord, as petitioner.
Detainee as the petitioner. The matter will be
Are you
interlocutory application.
No.
Okay.
Today, no?
This is your lordship. Lordship, I beg to mention item number 14. The arguing counsel is not in Guwahati right now for medical emergency. And the matter may be taken up for after 2 weeks. 14. Published.
May I please, Your Lord. Also, I beg to mention for listing of a IA which has filed for correction of the order.
This is given to the court.
May I please, Your Lordship. I beg to mention item number 7, Lordship. I am suffering high fever, Lordship. Only next email. 7.
Based on 1/9/2025, that's patient.
Obliged.
May it please, lordship. Lordship, I beg to mention item number 6, 12, and 19, your lordship.
6.
6, 12, and 19, your lordship. Lordship, arguing counsel Mr. A.W. Aman unable to appear before this court due to some personal bereavement in his family, your lordship. His aunt passed away yesterday night, your lordship.
6, 12, and
19, your lordship.
19. Okay. As Mr. A.W. Aman, the petition is in development. List
High level.
after week.
Lordship, next week. Sir, after.
It's like,
Yes, high level.
May I please, Lordship? Item number 30 and 47, my lordship. Both petitioners are in detention, my lord. Matter may be taken up after motion completion.
30 and
39 and 47.
30.
After completion of motion, my lord. Both are behind.
39 and
39, 47.
47.
okay.
May it please your lordship, so I beg to mention item number 30 for your lordship. I'll pass over the matter for the day.
After week.
Bless.
Please, Lordship. I beg to mention WBC number 333 my lord. It was leftover matter, my lord. It was listed on.
I beg to mention item 29.
Committee is already mentioned.
29.
Mentioned.
Item 321. This is not the paper.
तो कुछ वाला नहीं इंस्पेक्टर पहले मरता
Near the went without one of us.
Hmm?
We have to do that.
Daily list item 1.
Please, Lord. Well, what happened, my lord, the matter was once, my lord, heard finally, my lord. And my lord, what happened, I have returned the file to the parties, my lord. So, my lord, matter I fixed for hearing, my lord, giving some time, my lord, so that I can take back the record and submit my arguments.
Okay.
After vacation, my lord, 2 weeks. Apologies.
Item 2.
Take it up for,
Yes,
we'll take it up for disposal some other.
Oh,
on admission stage.
actually petitioner is not on interim. Bail has not been granted.
Has she been apprehended? Has she been apprehended?
Judgment is of 2019. Yes,
No, she's outside.
outside you. Sorry.
Both sides are represented. The records called for from the learned tribunal have been received. It's the matter on next week. On 1st of September 2002. In the admission column. It up on Monday.
There is an order not to be deported, Lordship. It is already there.
On Monday, we'll take it up.
Yes, Lordship.
The brother has been
Brother,
declared as
brother,
Indian,
brother.
but the sister has been declared a foreign. Same documents.
May not be from the same parents, Lordship. We'll go through it. Yes,
Item 3.
May it please your lordship. In this case, lordship, this petitioner has been declared as a foreigner, lordship, order opinion on 42, lordship. Here, lordship, lordship, allow me to file additional affidavit because sister has been declared as an Indian, lordship, on the same document, lordship. That was not placed during, lordship. Subsequently, I have received that is the order, lord.
enter examine for. I think enter examine.
But Mr. B. Chaudhary learned counsel for the petitioner who prays for a week's time.
Lordship, 2 weeks time.
2 weeks time to bring on record.
His father has been registered as an Indian citizen, lordship, and that document was, lordship, testified during her sister.
To bring on record subsequent documents by way of an actual affidavit. Prayer is allowed. It's the matter of 2 weeks.
Where this document exhibited?
Lordship,
Lordship,
that's why,
these documents were not exhibited before the tribunal.
but the
Can
lordship,
you bring it
can-
on record? We see.
Yes, he can bring it, but they were not exhibited before the tribunal, Lordship.
22.
2020.
And moreover, lordship, the document which is reliant, lordship, that is exhibit therein and this petition also, lord.
Once you bring it on.
Yes, lord. Highly obliged.
LCR would be of two opinions, Lordship, then. The second LCR may also,
That record may be called for, lordship, this is a case.
let him file, Lordship, then.
Yes, yes.
Required, the LCR may also be called.
Yes,
for.
lord. Highly obliged.
Item 4.
Item 4 to dear son. So item 4 dear son. Not. 20. Extra copy আছে নাকি? এই দুটা কপি সার্ভ করছে। এই দুটা। তিনবার মোর নামত করেছে। রিপেয়ার। রিপেয়ার করতাম না? এক সপ্তাহ হওয়া নাই। একটু নামটা লিখে দিই।
4. Both sides are represented. The records of the trial court as called for by order date 26/5/2020 has been received. So, issue notice returnable on 3rd of September 2025. Since all the respondents are represented, you have copies. Nitama, you have got copies?
Yes, Lordship.
Since all the respondents are represented, formal steps are dispensed with. List on 3rd of September in the admission column.
Item 5.
May I please, Mr. Chaudhary? In this case, the brother of the petitioner was arrested by Komargaon police under Golaghat district. Originally, he was a labor of brick industry, and on 25/5/25, Komargaon police has arrested him, and the family come to know from the supervisor of the brick industry that police has arrested. After police arresting him, the family has not getting any information about his whereabouts. So, my lord, without any other option, the petitioner is before you. There is ex parte order. Look. Look.
Lordship, can't hear Lordship clearly.
The records, when can you get it? Monday, Friday?
This is from Golaghat, Lordship, at least a week.
Only
This
information got it
information
Monday.
We can get it on Monday, next Monday.
Next Monday.
Right.
SU Ahmed.
Ahmed, respondents can take it. Petitioner has submitted that his elder brother, namely Momor Ali, was taken into custody on
25 May.
25 May 2025, and since then his whereabouts are unknown. Accordingly, this writ petition has been filed under Article 226 of the Constitution of India. It is stated that the brother of the petitioner was declared to be a foreigner by opinion dated 18/3/2025
Senior Secretary.
Ex parte order.
by the Learned Member Foreigners Tribunal, Jorhat in FTG 999 of 2011. Huh?
Everything.
Page 15.
25.
As the petitioner projects that his brother has been taken into custody and his whereabouts are not known, we request the Learned Standing Council FT Matters to obtain information as to the place where the brother of the petitioner, namely Momor Ali, Mumur Ali, is presently lodged, if not already deported, and if the brother of the petitioner has been deported, she shall provide information as to the place from which the father of the petitioner was deported and the manner of deportation. The Learned Standing Council for the FT Matters is permitted to send a downloaded copy of this order to the concerned authorities to enable her to obtain information and inform the court accordingly. List on 1st of September.
Yes, Lord.
Mohur Ali, son of Sohar Ali, SOHER, খালি মানে কিছুমানৰ চেম নাম হৈ যায় যে
Extra copy.
মমৰ লিখিছে মোৰ
What is the actual name, Momor or Mumur?
Momo, as per their record, it is Momorel. MOMOR.
The FT record says MUMUR.
In FT record,
just
MU.
মমৰ আলি MUMUR within brackets also spelled as
Momor.
মমৰ MOMOR okay.
Lordship, I've just noticed the police inquiry is at Golaghat and the permanent address is at Dhubri. That
Yes.
means he has changed his place without informing the police. Let the records also be called.
My
for
lord, we have no
lordship
knowledge
that-
about the FT case. So,
Lordship,
how-
he cannot say that because if there is a police inquiry,
Let us first find out whether he has been deported or not.
no,
If something has happened to him. If not, then we will go in court.
yes, Lordship.
Not at this stage. Let us first find out what has
Because-
happened to him.
Because the present prayer is only for the whereabouts. The challenge is not made. So there was
Yes.
no point getting that record.
Yes, Lordship. No, because he's annexed all the voters list. That's why I was wondering. If he had everything, he could have
He's only habeas corpus. We just need to know where he is.
get that
Rest-
instruction, Lordship.
Item 8.
But you give her extra copy.
Oh.
Give her an extra copy, otherwise.
Extra copies, huh?
May I please issue lordship?
6, 7,
It may be possible for 10.
6, 7, he will hit that.
Time B.
Conducting counsel is on lead.
Okay.
7, Six to 4, 6 to Torapalli. I'm a copy for Torapalli copy for.
It will fine.
8 to Tanvir.
Item 9.
Where is the-
Lordship, in this matter, LCR has come, he is not to be deported, the order is there. So matter may be fixed for hearing in the admission column, Lordship.
बाहेर
27.
He's projecting that his 3 brothers are Indian,
yeah.
but where are those judgments? You did not place it on the last occasion. Because we did not call for the other records.
Lordship may you examine the other 3 records also, Lordship.
We'll have to get it.
This is the expert here.
No, whatever it be, but unless you tell us, we did not call for the records. Unnecessary, you are. Because we did not consider your bail, did not point out before us on that day. You just say all sides are represented. In view of the projections made in this petition, that the records of page 24
Time.
only one. How many brothers were declared Indian?
Two brothers, my lord, one is my lord, I have got 35 to up to 20, my lord.
In your synopsis, you have given three cases.
Okay.
341, 342, and 343.
My lord, one, yes, my lord, three, my lord.
How many are there?
Two are received, my lord. 41, 42, 43.
41, 42, 43 makes it three cases. So either there are three brothers.
Apa itu suatu nasin itu?
Super accurately estimate. That means you're four brothers. Nothing but you're four brothers. Three declared Indians.
Yes, yes. Boleh kita lihat surat. Brothers kita apa? What 7 brothers can kita? That number Rofitul, Mufidul, Shodipul, Muzahidul, Mukhtar. এক, দুই, তিনি, চারি, পাঁচ। এক, দুই, তিনি, চারি, পাঁচ, ছয় ভাই। Six brothers.
Bring this on record.
Yes, my lord.
File an affidavit being both on record. Thereafter we'll call for the record.
Yes, please. In the meantime, some protection may be given me.
No.
This is the expiry order, my lord. Petition did not receive
We
any
understand
notice.
letter.
Notice sent to the Nam Kahanda, my lord. Petitioner residing at Upar Kahanda, my lord.
We don't know. There are reasons. We have our own different reasons. Mr. A.M. Ahmed, counsel for the both sides are represented. Mr. A.M. Ahmed, counsel for the petitioner, has submitted that although in the writ petition, he has referred to 3 opinion as an HSC series, but he has only been provided the opinion, the copy of opinion passed in FT case number 342 of 2016 and FT case number 343 of 2016, out of which the opinion in FT case number 343 of 2016 has been annexed. Next paragraph. That the said to opinion be also brought on record by way of an additional affidavit, upon which the orders will be passed on the next date for calling for the records of the other 3 cases. You can do it by Monday?
Milord,
You can do it by Monday?
next Monday.
List on 19/2025. The interim order of the passed on 21/7/2025 not to deport the petitioner shall be extended till further orders.
Obliged.
Item 10.
Maybe. Plus today's consideration for bail, my lord.
What is the best document you have to connect you to your parents?
My lord, page 40, my lord, Jamabundi, my lord.
Page?
Page 40, my lord. This is my name and my mother's name, my brother's name also, my lord, recorded, my lord, by right of inheritance, my lord. By this document, my lord. And the contents of these documents also proved by the official authority member.
Which page is the entry of your predecessor, Gyasuddin?
My lord.
In this document, where is the name of your Gyasuddin, your predecessor?
My lord, kindly see column number 10,
height order dated 14/6/2086.
No, don't trust the type copy of the order. From the original one at page 41 onwards, there is
Yes.
the entry of Gasuddin.
Yes, my lord. This.
Name of Gasuddin and the remark column, corresponding remark column of entry of
Yes, my lord, I am.
Gasuddin.
Yeah, I agree. My lord, page 46, my lord,
46.
page 46. From bottom onward, my lord, third paragraph, my lord, 1 बीघा 15 लेसा माटी मोहम्मद আব্দুল হে আবু চন্দ্র আজিজুর লগত আব্দুল কালাম হাফিজ আহমেদ পিতৃ গিয়াসউদ্দিন ওর নামত নামকারী হল গিয়াসউদ্দিন।
এক বিঘা 15 লেছা মাটি. That one. You are referring to which entry?
My serial number is 57, my lord. My name, my lord.
No, that page 46 you are referring to which entry here? In page 46.
46, my lord.
This does not have Gasuddin. You wanted to see the name of Gasuddin here.
No, my lord. Proceeding is my lord, my lord, Mozida, my lord.
We know that. The mutation was made in place of Gasuddin.
Yes, my lord.
Where is the Gasuddin?
My lord, finally, page 41, my lord. 41, my lord, from bottom, my lord, খ সরজমিন চিঠার 14/6/86 তাং হুকুম মতে হুকুম উত্তরাধিকারী সূত্রে কট্টার 139/140 জগৎ মৃত্যু গিয়াসউদ্দিনের স্থলত
Abul Kalam.
Yes, my lord. These are the brother.
Who is Abul Kalam?
Abdul Kalam, my lord, is brother, my lord.
You see, if the entry is correct,
My lord.
in lieu of Gasuddin, the name of Abul Kalam has come. So after he has already been substituted, how can his legal heir's name be again included in the Jamabandi?
My lord,
Salat means in cancellation of the earlier name. So he did not take by inheritance. He took it by way of a purchase. After his rights are not there, how can the name of the petitioner and other family members be again mutated by way of inheritance?
My lord, it was, my lord, in the year 86, my lord.
No, whatever be, you see, you are showing us the entry. Here is not material. We are going back prior to 1971. So here is not material. You read it and be prepared. We'll take it up at 2 o'clock.
These documents also proved by the official respondent, my lord. That is, my lord, find the page.
No, that is proved, we understand, but
Right.
that's why we wanted to see the entry. You take, your name is substituted in place of Gyasuddin.
My lord.
Now, where is the name of Gyasuddin? In respect of Gyasuddin, you refer to page 41.
My lord.
Here, his name is already cut. Stholot.
The date of birth, the typical line required.
Clock. You be prepared, find out that entry. We'll take it up at 2.
My lord. My mother's name also, my lord, there, my lord.
Item 11.
May I please, your lordship? Lordship is an expert opinion dated 2021, lordship. And I have been arrested on 29/5/2025. And since then, I am in detention camp, Matria, lordship, welfare. Yes, it would. This is the first page of your opinion. No. Page 27. Page 26. I can type page 26. I'll type another. Yeah.
It is the date of the 18/1/21. And I would respect the petition, but the petition.
PM Saikia.
October. Item 13.
May I approve? In order dated at phase 1925, Annexure 1. 19 to 25, Annexure 1.
You'll have to wait for some time for bail.
My lord,
You'll have to wait for some time for bail. Consider it after receipt of records.
it is on
Heard, Mr.
third, SU Ahmed, third term.
S.U. Ahmed.
SU Ahmed.
S.U. Ahmed, Land Counsel for the petitioner. All the respondents are there. Same order, opinion dated 25/1/2024, page 19. Asked by so-and-so, case number so-and-so, reference IMDT case number so-and-so. By declaring the petition to be a foreigner of post 25/3/1971. Notice extra copies, notice returnable on same date.
13/10.
Obliged.
Extra copies is included. Call for the record on the following email address of the Illinois Tribunal. The prayer for bail shall be considered on receipt of records. In the meantime, the petitioner, namely Rustam Ali, is detained, he shall not be deported out of the country without order of the court.
Obliged.
Item 15.
May I please order is on page number 100. Order is of dated 14/5/2025.
Mr. So-and-so. Appearing to the petitioner and to the respondents. The present petition under Article 226 of the Constitution of India has been preferred, assailing the opinion dated 14th of May 2005, rendered by page 100, rendered by members Final Tribunal with Morigaon, Assam, in so and so issue notice which the respondents are represented. Formal steps are dispensed with. However, extra copies in requisite numbers is served on the council for the respondents within a period of 3 days, 3 working days. Heard on the prayer for all for the records. Heard on the prayer for interim bail. Though the prayer has been objected to by the learned council, preparing for the FT members, FT matters. In view of the projection made in the repetition, we are inclined to grant bail. The petitioner shall the petitioner shall furnish the copy of this order to the SP border Morigaon. Bail to the satisfaction of SP border Morigaon. List on the this after 4 weeks, along with few of the records file for
16.
May please your lordship. May please your lordship. This is an export the opinion on page 46, man.
FA Hassan for the petitioner also. So and so this petition under Article 256 has been preferred against the order dated 11/4/2025.
Yes.
Page
46.
46. The order dated 11/4/2025, passed by Foreigners Tribunal Tejpur, 7th Tejpur. So issue notice returnable in 4 weeks since the respondents are represented. Formal notices dispensed with. Extra copies within a period of 3 working days from today. All for the PCR. Heard on the prayer for interim bail. The prayer has been opposed by the learned council for the FT matters. However, in view of the projection made in the repetition, we are inclined to grant bail. So, subject to SP border, Sonitpur, HP border, Sonitpur.
Obliged.
18.
May please your lordships. My lord, impugn order case, my lord, 109, my lord.
Attendance will be heard so and so. Heard so and so. By preparing this writ petition under Article 226 of the Constitution of India, the opinion rendered on 28/11/2023, page 1096, by the member Foreigners Tribunal 6th Porpeta in connection with FT case number 158 of 16 has been assailed, by which the petitioner has been declared to be a foreigner of the post 1971 era. Issue notice returnable 4 weeks. Since the respondents are represented, no formal notices are dispensed with. Extra copies within a period of 3 working days today. Heard on the prayer for interim bail, the same will be considered on receipt of the trial court records. Is however provided that if in the meantime the petitioner is apprehended, he shall not be deported. He shall not be deported without further orders of the court. List after receipt of trial court report.
My lord, case, my lord, I have actually a clear case, my lord, in this case. Just kindly see at page 48, my lord.
Not without the records.
My lord.
Let us not go without
Others-
the records. He
Obliged,
will not be deported.
My lord, my lord.
Given is the protection.
My lord.
He will not be deported if apprehended.
But my lord, maybe my lord, arrested, my lord, that's a.
Uh-huh.
Maybe arrested, my lord, in the meantime, my
You
lord.
will not be deported. 2023 order. This is
Obliged,
25.
my lord, after receipt of it. Obliged, my lord.
Item 20.
May I please? Lordship, kindly see the imperial order dated 19/2/21, Annexure 1. Annexure 1, imperial order dated 19/2/21. Page 22. Page 22.
Your name?
Lordship,
Your name?
SR Das.
Heard Mr. Sada, then counsel appearing for the petitioner also heard respondent in petition. By preferring this petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion rendered on 19/2/2021, page 22, by the member Foreigners Tribunal 9th Dhubri, Assam, in FT case number 9 of 180 oblique GKG oblique 2017. Issue notice returnable 4 weeks. Since the respondents are represented, formal notices are dispensed with. Extra copies within a period of 3 working days from today. Call for the trial court records. The prayer for interim bail shall be considered on receipt of the trial court records. It is however provided in the meantime, if the petitioner is apprehended, he shall not be deported without further orders of this court. List after receipt of trial court record.
21.
May it please your lordship.
Lordship, page 88 is the impugned opinion of 88.
All the responses are there. Page 88, opinion dated 2/6/2025, passed by so-and-so in case number so-and-so, our case number so-and-so, thereby declaring the petition to be a foreigner post 25 to 1971 stream. Notice returnable in 4 weeks. Extra copies within 2 days. Call for the record. Prayer for bail is opposed by the London Standing Council for the FT matters. Considering the projection, 10 days time to take bail of ₹5,000 to the satisfaction of SP Border,
Borpeta Lordship.
Borpeta. List of offenses on receipt of records.
Deeply obliged.
22.
May please the Lord. My lord, the impugned opinion at page 77. My lord, there is delay, that is a fact, my lord. And there is we have an explanation, my lord. One advocate, the respondent number 5, Dhubri, has taken the responsibility to file a writ petition before the Supreme Court. He was paid and he was given the entire file, but ultimately, my lord, did not do anything, my lord, and returned the file only on 1/7, my lord. July, 1st July of this year, my lord, he returned the file. Then only, my lord, it could be filed, my lord. We have explained in paragraph 22 and 23, my lord. And also complaint has been lodged against him in the bar.
ভারত জয়ের দরকার নাই, আমি রিজেক্ট করবো পারি। Mr. Sikdar,
My lord.
this complaint at page 82 appears to be an eyewash because the bar council,
My
we
lord.
were told that they would also take some fees to entertain complaints. The receipt is not there.
My lord.
We were told some time ago that the bar council, on accepting complaints against advocates, also takes some fees. They give a receipt. The bar council gives a
My lord, you
receipt.
complaining the bar association in Dhubri, my lord.
No, they
not
will not
bar
do
council,
anything.
my lord.
They will not do anything. Okay, keeping the issue of maintenance open, we are issuing notice. But this is not satisfactory.
Lord,
Mr. A.R. Sikdar,
we have made
the
30, my
petitioner,
lord.
all the respondents are there. Opinion at page 77, dated 38/2018, passed by so-and-so in so-and-so, thereby declaring the petitioner to be a foreigner post 25 to 1971 stream. Next, we have the inordinate delay and latches in asserting the opinion, keeping the issue of maintainability open, issue notice returnable on so-and-so. Extra copies within 2 days, call for the relevant records. Next, the prayer for bail shall be considered on receipt of records. In the meantime, if the petitioner, namely so and so, is apprehended, shall not be deported out of the country without order of the court. So just before that, second paragraph, heard so and so. The learned counsel for the petitioner submitted that the delay in approaching this court is attributed to respondent number 7. First off, as the court is not the authority under which respondent number 7 is subjected to, comma, the court is inclined to strike out the name of respondent number 7. Stop. The registry shall do the needful. After that, need to notice. Respondent number 7, we are striking out the name.
My lord. My lord, till then, my lord, receipt to the record, my lord, not to be deported, my lord.
We will give that, not to be deported.
Deep lovely.
My lord, 23.
In 23, my lord, we have challenged the second proceeding. Earlier, he was declared not foreigner by order dated 39/2016, Lords, you will find at page 23. Then, my lord, the second notice petition was filed for my lord, setting aside the second proceeding under application of red judicata. That petition was rejected. We are against the second proceeding.
But this, Mr. Sigdar, this order is correct.
My lord.
Because the finding is that whether these persons are same, he'll have to arrive at a decision. The court takes cognizance of, the tribunal takes cognizance of the first opinion, but it has to decide whether the proceedings are same or not.
My lord, who is to, my lord, decide the, my lord, this person is same, that should be verified, my lord, if required, my lord, it should be by the border police, my lord. Same person, same documents, my lord, the documents which are enclosed in the WS, that documents, my lord, are the documents which were exhibited in the previous proceeding. Mere verification of the documents is enough.
No, but you see, the tribunal, the opinion under the Foreigners Act and the foreigners tribunal order must result in an opinion. There cannot be any other order except for opinion.
My lord, then the principle of writ judicata, my lord, how will be applied, my lord?
How does it apply
My
in a
lord,
suit?
my lord, I
How
am,
does it apply in a suit? If there is a suit and plea of res judicata is taken, how do you decide? How does the court decide that?
my lord, that should be, my lord, based on the pleading in the suit and the earlier judgment.
Correct.
Pleading, my lord, here in
must
the
be-
tribunal case, my lord,
First requirement is that
Tribunal-
it should be a proceeding between the same persons.
my lord, tribunal in the FT case, my lord, there is no plaint, only the government inquiry reports and the notice, that should be verified.
First
If
requirement,
the inquiry reports notice resembles the same person in the previous judgment, that is enough, my lord. Here, FT case, my lord, no plaint by the plaintiff. Here, the government is the prosecutor. Their documents, inquiry reports, their my lord, notice, these things are sufficient to verify. My lord, if the principle of res judicata, my lord, section 11 is to be considered, then my lord, the inquiry reports, notice, materials available in the record is to be verified whether the person is same or not. That much is enough, my lord. That is judgment of that. Lord, the one judgment has been relied by the tribunal. And there is one paragraph which goes to show that the tribunal is wrong. In, my lord, I'm one copy, my lord, only. Paragraph 5. No. Supreme Court has that. Supreme Court has that. Order of Nikas. Bishop Sud versus Kiki person. Paragraph 5 is relevant for us, man.
given a copy of the notice that you received?
My lord, yes, my lord. Notice, lordship will find. Annexure 2, my lord. Page 27. My lord.
Do you have a copy of the written statement passed, filed in that case, 127?
My lord, my lord, I have not annexed, my lord.
Please, if you have, just show it to us.
My lord, this. Part of it. Okay. My my lord, not available with us, my lord. If required, my lord, we can file it, call for the record from.
Which you have taken,
My lord,
I will tell you the reason for it. And that's
My-
why we wanted to look at the written statement.
My lord.
Please come to page 23.
Yes, my lord.
This here, line number 3, you see, is Jamiruddin Mullah, Mulla.
Mullah.
Yes, and in the notice which you have shown at page 27, spelling is differently written. Page 27, page 28 also the name is differently written. And please come to your written statement at page 29. Paragraph 2, again, this is the same name, differently written. Then there is another.
My lord,
You will find the address which is
My lord,
given.
in the paragraph, first paragraph,
We'll tell you something.
DW1 Jamiruddin Mullah, that is Mullah, yes, my lord.
No,
Only H is.
no, not only that, not only that. You see, page 23, line number 4, village is Pub Mahachara, Yes Tarabari. Now, in this,
My lord, there is shifting, my lord.
no, we don't know.
Mahasara, then Sudhiripara.
No, we don't
These
know.
are they are shifting.
Please have patience. Now, here you have writing.
My lord, therefore, my prayer is, my lord, it will be better.
Please, you have annexed a copy of Jamabandi.
My lord.
as an extra copy of Jamavad is there. But you see this notice at page 27 is issued at village Pub Mahasara non-K. It is non-cadastrally mapped.
My lord, that is their, my lord, Chaudhuripara is their, Chaudhuripara is the main village. There are shifting. That pleading is also there, my lord. In the previous case, in this case also. In the page 24, in the top of the page, have mentioned the subsequent village.
Yes.
Lordship will address Lordship when Lordship returns. We have also gone through the documents. Aziz Mia is there. Aziz Mia Lordship is reaffirmed by Lordship's judgment also. Just looking into that.
Which one?
I think we have to take it. Network here is very bad, Lordship. We couldn't get it. Lordship, it's WPC 2370 of 2023. Aziz Mia, Elias Mohammed Aziz Mia,
WPC
2370 of 2023.
decided on
Lordship decided on 9/6/2023.
name of the parties.
Aziz AZIZ, Aziz Mia MIYA, Elias Mohammed Aziz Mia MD, Bookshop AZIZ MIA. Lordship, it's on that police inquiry does not give finality to the on one and the same person. And Lordship has even reaffirmed it is in a Lordship's own judgment.
No,
That
no,
is
the
Lordship.
inquiry is concerned. This is regarding the inquiry concern.
Yes.
He has been declared by the, in one of the cases, he's been declared to be an Indian.
Aziz Mia does not apply.
We have judgments on that also. It has to go back to the tribunal. It is only the tribunal which will bring it to its logical conclusion, Lordship. The tribunal will decide whether it is one and the same person.
That is what he wanted the tribunal to do. Tribunal
Yes.
is refusing to do it, saying that we will take the whole evidence and thereafter we will decide whether you are
Yes,
one of the
Lordship,
same.
he has to submit he has to complete the proceedings. There are some judgments, Lordship will give us some time, we will place those judgments. And Lordship has reaffirmed this, Lordship Aziz Mia, Lordship's own judgment in WPC 3500 of 2018, Lordship, decided on 6/1/2025. Muhammad Ali versus Union of India. And it has both the things, Lordship, improper advice of the advocate and Aziz Mia reaffirmed. And the other part, Lordship will just look into it and share it with Lordship.
My lord,
You have a copy of that order, the subsequent one?
Lordship, I don't have the copy, but I have just written
I can-
Okay, then we'll take it up on Wednesday.
My lord,
Yes,
there is a recent judgment of Supreme Court, my lord. That is reported in 2025 4 GLT, SC 36. My lord, in the second proceeding, notice was issued only. Then we filed High Court petition. High Court petition remanded back to contest the case again. Then we approached the Supreme Court. Supreme Court, my lord, has set aside the entire proceeding. That is the recent judgment of Supreme Court, my lord. Banu case, my lord.
First, is not present. Yet he returned.
Section 2 problem.
Position is more than
Next time, right?
Reporting number to me, the governor with the people. Report to us. Yes, in the last point. Is 15.
Mhm.
Recently, it's just like last put it. ZLT report. SSC. Is my mistake. 92 to 20 to 4 4 0 2. The work that was silent.
Ako pala tampas sakit. Takto nuaro na. Rafi to nuaro.
Documentary. 20.
Yeah, 25.
Heard Mr.
J.A. Sikdar.
J. Sigdar, counsel for the petitioner. All the respondents are there. Page 55. Opinion dated 37/2024. Asked by in case number so. Thereby declaring the petitioner to be a foreigner of post 25 to 96 plus stream. Notice returned within 4 weeks. Call for the record. Extra copies within 2 days. The prayer for bail shall be considered on, the prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Morigaon. List after 4 weeks on receipt of records.
27.
Opinion is on page number 109.
Twenty-five.
25. If it's only 1 month delay.
I was also wondering why lordship changed.
But if for 1 month, it can be considered. No deportation.
1310.
Lordship opinion is at page number 109. Dated 24/11/24.
Second round of litigation, lordship.
109.
Actually, super gold. I put super for it. But they still get the benefit of 2016 or IMDb reference. Lordship, we can we can put that in the car.
No, you can go. Maybe.
They don't want. Even if it's let's say like this is a back to back.
And question the FT matters. Considering the projection,
Look, interesting.
below rupees 5,000 to the satisfaction of SP border,
Morigaon.
Morigaon.
Black.
28.
Money you have. It requires money you have.
May I please your lordship? Father of the petitioner purchased the land in 1964.
Opinion, which page is the opinion?
Opinion at page 79.
You have to wait for some time for bail.
Uh, the operative portion says there is no linkage, lordship. Whereas there were many documents, lordship.
No, whatever be the good reason, but since there's more than, you come after more than a year, we are not granting bail.
You will not be deported. That's it, okay?
Your name?
GJ Sharma, lordship.
Dr. G.J. Sharma.
Dr. G.J. Sharma, you paying for the petitioner? Also heard respondent attendance.
24. Okay.
This petition under Article 236 of the Constitution of India has been filed. It's saying the order dated 29/1/2024, page 79. Issue notice, returnable 4 weeks. Since all the respondents are represented, formal notice are dispensed with. Extra copies within a period of 3 working days from date. All for the TCR. Prayer for interim bill will be considered on receipt of the TCR. However, in the meantime, it is provided that if the petitioner is apprehended, he shall not be deported without further orders of enforcement. Please compare it.
You examine with her, you're going to get benefit of the new scheme.
There is some scheme. And find out.
Amendment of the Citizenship Act. Look into that, make it.
List on the 13.
Before, what is it about?
Time being item 8.
Lord, this is that heaviest purpose, my lord, and we have been allowed to, my lord, meet, and my lord, along with its signature has also been obtained. Now, my lord, on the last occasion, my lordship, an affidavit we have received, my lord, from the, my lord, Border Security Force, Inspector General, my lord, wherein they have also admitted that the, my lord, detainee is now within their custody, but she has not yet been deported, my lord.
Yes.
Sure, sir. There is one. Mariam Begum. Lord, admittedly, my lord, the order ex parte passed by the my lord Foreigners Tribunal has attained finality, and till date, my lord, it has not yet been put into challenge, my lord. My lord, that. So, my lord, I have to obtain the instruction, my lord, that what is the current opinion, because, my lord, what has happened as per the regular order passed by the, my lord, Honorable Apex Court, my lord, he was on bail. My lord, with the terms and conditions which has been put, but my lord, later on, he was picked up for the purpose of pushback, my lord. And but I think, my lord, she has not yet been pushed back and is still at the detention camp, my lord. My lord, these are the people within, my lord, with a, my lord, imagination that as I am on bail, my lord, therefore my troubles are over. My lord, in many cases, my lord, I have seen in that type of attitude, my lord. So, my lord, may I pray, my lord, that I will take necessary instruction from the, my lord, the petitioner as well as the person of in this petition also, my lord, that whether, although there is a delay, my lord, we'll try to satisfy, my lord, if that is put into challenge, my lord.
So once you have received the Vakaratama, you can make a
My lord,
challenge.
my lord.
The purpose of this writ petition,
My lord, we have made a prayer in this petition, my lord, the prayers which my lordship has already considered once, my lord. Prayer number D, my lord, direct the not to resort to deportation of Mariam Begum without following the due process and maintaining utmost transparency. So, my lord, basing on this prayer D, my lordship was pleased to, my lord, direct the respondents to file an affidavit, my lord, on the last occasion. But, my lord, that affidavit has not yet been, we have received, my lord.
in this writ petition, what is the name of your sister?
My lord, Mariam Begum, my lord.
Where have you said that?
My lord, prayer. Sister of the petitioner, my lord, the name. Mariam Begum नाम ट्रांसफर करना है प्रेयर ऑफ दिले कने का प्लीडिंग स्टेप नहीं है
Here, we don't think you have said anywhere that she's your sister.
My lord, in the pleadings,
I'm the brother of so and so. That positive statement is not there.
That is that appears to be, my lord, not clear in the pleading, my lord. Lord, what has happened, my lord? Very hurriedly, this petition was filed, my lord, because at that time that pushing back exercise was taken out. That's why, my lord, perhaps we have missed out. Lord, I can, my lord, if my lordship allows.
Close this writ petition by saying that if you are expelled from the country, it will be done in due process of law.
No, my lord, in prayer, we have mentioned, my lord, for production of Mariam Begum before the court. But, my lord, admittedly, my lordship is, my lord, in the pleadings. It is not specific, my lord.
No, not that. Once you have visited her.
Yes, my lord.
And
Wakalatnama is, my lord, executed.
Has been obtained.
Then my lord can close it with a liberty, my lord, then we can, my lord, for the purpose of challenging the expertise or, my lord.
You can do it, whatever.
My lord.
And if he is to be expelled, then it will be in due process of law.
My lord.
Heard. Mr. A.R. Bhuiyan and counsel for the petitioner also heard so and so for the respondents. Next para. The The learned CC has submitted that an affidavit in opposition has been filed on behalf of the Border Security Force. Next para. The learned counsel for the petitioner has submitted that pursuant to the order dated 25/7/2025, the petitioner, namely Abdul Khalek,
Aye.
has been allowed to meet his projected sister, namely, Mariam Begum, Mariam, Mariam Begum, but your stand is inconsistent with the stand of the BSF. They say that there is no Mariam Begum in their custody.
Lord, in affidavit, mentioned that writ petition agreed by the sister, namely Mariam Begum,
At holding center. So you have visited the holding center.
my lord.
She was not handed over to us. Mariam Begum was not handed over to us. So she's in the detention center.
Okay. We visited her at holding center at Matia Gwalpara.
In para 3, my lord, they have denied.
Hmm.
My lord.
Stop.
Wakalat
Not full stop, and he has also collected the wakalatam of the detained person. Next para.
information to the title signature to
It appears from the materials available on record that the said Mariam Begum was declared to be a foreign illegal migrant of the foreigner. Wide opinion dated 19/3/2012,
12, my lord.
passed by the learned member from a foreigners tribunal in Nalbari. Where is it? Case number?
My lord, that case,
FT Nalbari in case number
yes, my lord.
capital FT
Case
within
20.
bracket NAL bracket close capital B dash 2468 public 2007. This is paragraph 3, page 5. So it also appears that the said opinion has attained finality without any challenge being made thereto.
Date to
Next, under the circumstances, as the purpose of this habeas corpus petition has been achieved, the court is inclined to close this habeas corpus petition without prejudice to the right of the detained foreign, declared foreign national, namely Mariam Begum, to take such appropriate steps as she may be so advised. Next paragraph. Insofar as prayer number D of this petition is concerned, the court is inclined to direct that in the event of expulsion of the detained foreign national named the Mariam Begum, the same shall be done in accordance with the due process of law. Stop. With the observation is made, with the directions has made above, on this petition stands disposed of.
Mal.
We've given the right to you to, without prejudice, this is being closed.
Deeply obliged.
Upgraded item 41.
Today, Lord, to affidavit is filed, Lord.
You took time to file affidavit, you have filed it,
Yes, Lord, today, Lord. But
you've given him a copy.
yes, Lord, copy not given. I inquired, Lord.
This is on first, then
Monday, Lord.
Monday.
Or Wednesday. Monday or Wednesday, case may be taken up. Lord.
On Monday, we are taking it up. You want Monday,
Lordship.
you wanted Monday,
Monday or Wednesday, as your Lordship is. But today, affidavit has been filed, Lordship.
is the representative. G. Sharma, the technical for the matters of the affidavit and document is being filed in court of the state. Let a copy thereof be furnished to the Learned Counsel.
For the petitioner. Next para. List on 1/9/2025.
Yes. Okay.
Upgraded item 35.
May I be left?
35, no?
Well, input order is at piece 87, my lord. I have been declared as per my lord only on the grant of age discrimination, nothing else. My elder brother also this was my lord as VW2. You have the original land documents?
My lord,
You have the original
my
exhibits?
lord, I have connected Jamabundi, my lord, that is page 44, my lord.
No, do you have the original exhibit with you?
My lord?
Do you have the original exhibits with
No,
you?
no, my lord, this is just, I have no original.
Because then we can't read anything. Your evidence we can't read. Ito. Payment.
But date, my lord, 24/12/1965.
If we read a document, not only the date, what is the document that we have to read? We can't find it out.
Home tunnel survey. Yes, not
Get
here.
it, we'll take it up next week. You get it from your, from the petitioners. When do you want?
My lord, these documents is not available at present. Original documents is not available.
No, then where it has gone? This is your record. This is the original tribunal's record.
Look, after 1 is.
Tell us a date. The photocopy of the,
September, my lord.
both as a representative, the
September.
photocopy of the records. Photocopy of the exhibits which are available in the TCR is not readable. Accordingly, we direct the petitioner to produce the original exhibited documents. Next, this on when?
5th September.
5th September 2025.
Upgraded item 39.
Oh, yeah, guys. I think so.
Oh.
39. You have to take it up.
There is a
You have to take it up after lunch. There's a request from the bar to take it up to accommodate lawyers who will be attending the meeting.
Yeah.
We'll be 5 minutes late, but we'll accommodate the lawyers.
Yeah.
Delay. तुझे मग काय ना आता कोण
আজিলৈ কিন্তু কিনি খোৱা নাই আজিলৈ কিনি খোৱা নাই দিগদাৰ আজিলৈ কিনা নাই নাই ইয়াৰ পৰা মই কেতিয়াবা লওঁ আচ্ছা মই ভাবিছো মই অকলে হেৰি খাওঁ চব একেই কোনোবা বেছি
সত্তই আশীফাল নে আশীতকৈ উপদেশ ভাল উপদেশতকৈ আশীফাল নে আশীতকৈ উপদেশ
দুয়োটাই ভাল আমার কাছে দুয়োটাই ভাল
फाइल नहीं किया है यार
Yeah.
Monday.
What's the meaning of the now? Exit. Diplomatic.
Nine to আহিছে
Thirty-nine to আহিছে নে নাই
I have
In-
annexed
in- in fact-
yes. Page 16 Miller.
Page 7, no, we go with the printings first. Paragraph 6 says, you see, first, in paragraph 5, you refer to notice,
Yes.
28/10/21. Then in paragraph 6, you say that you appeared and filed written statement on 27/11/19. That is not in sequence. Then you refer to lockdown. But this notice you received was after lockdown.
Yep.
And after that, there is no explanation.
A date of written statement is, I mean, 27th day of November 2009.
Correct.
Maybe my learned advocate did not take any steps earlier.
No, but then you see, come to page 5, paragraph 2, last part. Now you say that the father of the petitioner is also
Yes.
declared as a foreigner.
Yes, already father declared foreigner.
Then you,
My lord, the
defense you will have.
petitioner tied to his linkage with his mother. His mother is Indian. And he's a indigenous Muslim community.
But that's not
That is
permissible.
Korea.
That's not permissible.
16 Muslim.
His mother is Indian.
But
He
you'll draw
has
your
to
parentage from
level based
father,
linkage with his mother.
but you'll have to draw your lineage from your father.
Father is already declared Miller foreigner Miller.
Then you can't have that.
I have stated in parameter.
You possibly can't give you an opportunity.
Mother is Indian Miller. The petitioner has only option to linkage with his mother Miller.
But is it legally permissible? You have to show us.
Miller as per citizenship act Miller. Either parents, one of the citizen of India. Other three cases Miller, two is brother and one is the sister Miller. The case is fixed on last coming 1st September. Miller. Yes, yes. Petitioners, elder brother, two elder brothers and younger sister. And they are also behind in detention Miller.
Those are also expired.
Yes, and yes, all are expert order. All are expert order. And they have also filed a witness case for vacating the expiry order. That is also rejected. Right.
Yes, Mr. Sharma. What is the
So what is the law on the point about acquiring of citizenship through mother? Can it be done?
Lordship, lineage could be done to other lordship.
Section 3.
Lordship, I think there is no infirmity in the opinion lordship passed by the learned tribunal and lordship regarding that lordship.
So
I
because you
think-
come to section 3 of the Citizenship Act, in page 5 of the writ petition, the petitioner says he was born on 31/12/1992. If it is 1992, then he'll be covered by 31B.
One of the students with
But where is the documents of your mother's father? Where is that?
I have not any, but
Then your plea will fail.
Lordship, I want to read few lines from Ayub Ali's case, Lord.
From,
Ayub Ali's case, Lordship, reported case,
yes,
2016 1 GLT 273. At first, Lordship, I am reading.
just a moment. Ayub Ali decided on
Ayub Ali decided on Lordship 15/12/2015
Ayub Ali.
in read appeal number 186 of 2015.
Citation, please.
2016 1 GLT 273.
it to 273.
273. I think Lordship, this case will cover the present case, Lordship.
Yes. Paragraph.
Lordship, I am reading para 10, Lordship. The petitioners appeared before the tribunal and presented their written statement on 20/4/2007. Two witnesses were examined on behalf of the state. On 14/6/2001, case was posted for evidence of the petitioners. On 16/8/2011, on the ground of ailment, petition for adjournment was filed, and accordingly, case was posted for evidence on 14/11/2011. After 3 months, on 14/11/2011, a petition was filed on behalf of the petitioners praying for adjournment on the grounds that they have not been able to collect their documents as well as due to sickness of the witnesses. On both the occasions, namely on 16/8/2011 and 14/11/2011, while granting adjournments, the tribunal had noted that medical certificates were not produced. The tribunal also noted in order dated 14/11/2011 that the plea that they have not been able to collect the documents at that distance of time could not be considered to be a reasonable ground for granting adjournment. Nevertheless, one more opportunity was granted to produce the documents by fixing the matter after more than 3 months on 23/2/2012. It was also recorded in the state order that if on the next date fixed, the witnesses were not ready with their documents, the tribunal will dispose of the case in accordance with law. Then para 11, once again, a petition was filed on 23/2/2012 praying for adjournment on the ground that though they had applied for voter list, they had not received the same. The tribunal rejected the prayer for adjournment and in absence of any evidence on the side of the petitioners, proceeded to hold that petitioners to be illegal migrants entering India after 25/3/1971. Then para 12 Lordship, section 9 was quoted, Lordship, of Foreigners Act. Then Lordship, I am coming to para 15, that the petitioners did not adduce any evidence is not in dispute. The first of the argument of the Learned Council for the petitioners is that the petitioners have been denied reasonable opportunity to enable them to discharge the burden cast upon them by section 9 of the 1946 Act of 1946, and one more opportunity should be granted to them. Then Lordship, para 16, principle of natural justice cannot be put into straitjacket formula. It is more than 3 decades that the issue of influx of foreign nationals has been in public domain in the state of Assam. Process of determination of question of citizenship cannot be a one-way traffic, leaning only in favor of the person whose citizenship is doubted. Interest of the state is also paramount importance in that undoubted influx.
has the potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very
No, but
valuable
Mr.
right.
Sharma,
and
that is
should be
one part of
guaranteed.
it.
Yes,
Mr.
no.
Sharma, that is one part of it.
Yes,
The second is a legal question with regard to the drawing of lineage from mother. Whether that can happen. Other cases are fixed when?
First September, 1/9/2025.
1/9. Then we
Yes,
take up this matter along with that.
Yes, ma'am.
Yeah,
Hmm?
yes, yes, yes.
Uh, Both sides are represented. Next, the learned counsel for the petition has submitted that the cases of other three members of the family is listed to be listed on 1/9/2025. List on 1/9/2025.
WPC 4229.
We are listing this matter.
Yes, yes.
My lord. My lord, only one thing, my lord, because the issue of section 3 of Citizenship Act will applicable, whether it will be applicable in case of this kind of cases or not. That was discussed in some other cases also. Because these cases are under 6C of the Citizenship Act, my lord. 6C is a special provision. When there is a special provision, my lord, then whether the general provision will prevail or not, that issue was there. That issue was, my lord, argued in some other cases, probably I have remembered. So that issue has been settled. That if they are claiming benefit under 6A, they will not get benefit under the general provision of law. If they are getting the benefit under, my lord, special provision, they will not be getting the benefit of the general provision of law. Because otherwise, my lord, 6A, my submission is that section 3 will not come into play if it is they are getting benefit under 6A. But because the foreigners tribunal, they are only taking the cognizance of 6A, my lord. Those cases which are coming under 6A. Otherwise, my lord, under section 3, if they are claiming citizenship under section 3, then they will have to show the lineage since 1951, prior to 1951. Because 6A, only under 6A they are getting benefit from 1971. 1948 to 50 to 71, this is relaxation under 6A, not under any provision of Citizenship Act. So if they are claiming benefit under 6A,
we will take it up on first, because three other cases of the same family are there.
Yep.
We'll take up this matter on that day. Sir, just make one more statement. it will be mentioned that pursuant to the previous order, Mr. G. Sharma, and standing counsel for the FT matters, has produced a scanned copy of the tables record. The same is written on it.
Publish.
Item 42.
No. 42.
The data was here, we'll pick it up after some time.
No, আমার নহয়। 42 আমার নহয়।
Upgraded item 43.
FT में FT Great. Great. Regarding pushback, whereabouts of the pushback, whereabouts of the petitioner. It is not related. 43. আগত আহিছিলে আৰু আগত আহিছিলো ৰিপোৰ্ট কল কৰিছিলো ৰিপোৰ্ট কল কৰিছিলো
Yes.
Oh.
You have visited the petitioner, the mother of the petitioner?
Pardon me?
Visitation right was allowed.
Yes.
Did you visit?
We have not visited yet, man. We have not, as per latest information, we have not visited yet, man.
You were here.
Have you seen the 11/8/2025 order? You are allowed to visit the mother of the petitioner. Motibur Rahman along with one family member can visit. Did you visit?
Well, we have not received any information regarding visiting as yet, my lord. But last last order to তোমাক কালি দিছিল last order to লৈছিল নেকি
Well, a counsel for the petitioner seeks a week's time to have updated instruction as to whether the petitioner has exercised the visitation permission granted by the order dated 11/8/2025. When a counsel for the respondents are present, is the matter again on 3rd of September 2022.
Oblige. Next million.
Upgraded item 44.
This is also similar.
Same.
78. No?
45.
No, please, Your Lordship, this is a habeas corpus matter.
Have you visited? Have you visited?
No, they have not been visited.
Why?
They don't have the resources to go up to there. That I have heard. They cannot go every time. That's the main reason, financial problem.
In Uttarakhand.
It's not possible for them.
Then we have to close this habeas corpus petition if you don't want to exercise because the whereabouts are known.
Yes.
It is for you to visit. Yes. Then we can only close it. We can't do anything more.
It can be ordered him to be released. No,
No, not in habeas corpus.
Okay. Yes,
But there's already an opinion against the husband. Mr. J.A. Sikdar. J.A. Sikdar.
J.A. Sikdar.
Sikdar, under counsel for the petitioner, upon instructions has submitted that though by the order dated 13/8/2025, the petitioner, namely, Saleha Khatun was allowed visitation right along with one family member to meet her husband, namely, Sonali Ali, Sonali, Sonali Ali, alias Sonali Sheikh, who is presently lodged at the holding center, 7th AP Battalion, Saraikota, Koprajar, he has not been able to exercise the visitation right due to a financial condition and she is unable to travel to Koprajar. Full stop. Accordingly, he submits that the detained foreign national be released on bail. Next paragraph. We take note of the fact that by an opinion dated 12/1/2018, passed by the learned member from a foreigners tribunal number 1 from a Kamrup at Ulubari in GFT within bracket R bracket close case number 413 of 2017. Comma, which has attained finality প্যাক করে দিয়ে একটু not essentially, which is the subject matter of WBC 2813 of 2018, which is stated to be pending. The court is inclined to
I think court is inclined to this matter along with WPC 2318 of 2018. The week commencing 1st September 2020. Wait one. Wait. 18. 18.
Item 46.
2813. Lordship, we are tagging this with 2813, where the opinion is challenged. Then we'll pass the order. It's okay. I'm not copy neither. Copy dictator. I'm not copy. Yes.
May I please your lordship? Your lordship may kindly pass over for time being, your lordship. Much of-
47.
May I be lordship? Petitioner was arrested on 28/5/2025. Pursuant to the order dated 23/2/2024.
Yes, what is the best document you have to connect you to your projected parents?
Parents documents is my lord. Voter list of 19, NRC 9 page 57 my lord. Abdul Khalil.
No, don't show us the NRC.
57.
Show us any other document you have to
Yes,
connect with
my
your
lord. Page
parents.
60, page 58, 66 voter list. Vernacular is page 59.
Where are the exhibited documents?
Milord,
Where are the exhibited documents?
page 59, Milord, voter list 66,
59.
59. And prior to date, Milord, page 57, this is the NRC of 1951, issued by the officer in charge, Sarbuk Police Station, in the year 1993.
Nothing voter list.
I'm
Unable to find a connect.
Milord,
You are unable to connect your documents.
yes, ma'am. In this case, Milord, one paragraph, page 83 of the judgment, Milord, paragraph 4.
That is 4 of the opinion.
Yes, in the paragraph 4 state everything, Milord. When the petitioner is in his mother's home, my lord, his father divorced her mother and separated the family, and subsequently petitioner was born. And petitioner was born and brought up as maternal grandfather's house Miller. And subsequently, petitioner's own mother also lived in Miller. And accordingly, he took shelter at neighboring village Gandharipara under Borpeta police station. And he has got married there and permanently settled there. But there is the fact which is stated in the written statement also Miller, reflected in the para 4 of the judgment.
Para 38. Para 38.
38.
Para 38. Page 94.
Oh,
There is one judgment in bold, a citation in bold. Just after that, the sentence starts with that apart.
Hmm.
Can you explain this part? What is wrong there?
you're unable to get a connect. But your father's name changes with every voter test.
And that is the voter list, my lord, not prepared by the petitioner, my lord. That is the prepared by
You
the authority,
understand
my
that
lord.
you see, you.
But it is admitted fact, my lord. His father shifted his residence due to erosion of the Becky River, my lord. Kamargaon to Boguriguri, Boguriguri to Betuman. As on today, Kamargaon nowhere, my lord. Was the idea. Talk to me, life insurance.
Yes. That's right, Papa.
My lord, my pair is, my lord, petitioner may be released on bail, my lord, and the matter may be heard further, my lord.
No. We are looking at your records only.
Petitioner is no way connected, my lord.
Hmm?
Petitioner is no way connected, lordship. Even lordship, his father and grandfather are also not connected, lordship. And lordship, if lordship will see the page 58, 40, 66 total list, Kulilur Rahman Akan, Mamid Akan, 42, Lord, is it about 42? Then lordship, see the 1997 total list, page 62, lordship, huge discrepancy of age, lordship. After 30 years, lordship only 10 years increasing lordship. Lordship, in the opinion, lordship, everything has been discussed, lordship. Really? opinion itself covers everything, Lordship.
Just AM with that part. There is also for the respondents. Matter has been heard based on 3/9/2025 for delivery orders.
Time being item 10.
Pardon me? We have fixed for orders on the 3rd of September.
For delivery of order.
The records. Yeah. Yes, my lord. Which is the best document to connect you to, okay, you got this,
Yes, my lord.
which is the best document to connect you to your protected parents?
41, my lord, my lord. That part is my lord, which is translated in page 41.
Page 41.
Page 41, remark column below portion, my lord. সরজমিন শিখার 14/86 তাং হুকুম মতে উত্তরাধিকারী সূত্রে পট্টার ইমান জাগত মৃত্যু গিয়াসুদ্দিনের স্থলত series to answer. These are my lord brother and sisters, and my name is my lord. Page 42, my lord. 1, 2, 3, 4, 5. Just below 4 persons, my lord. That is Sri Mozida Khatun. This is my name, my lord.
Our query was,
My lord.
when was your father's name?
My lord.
When did your father's name enter into the document? By which one?
Yes, my lord. There, yes,
That is your or query.
that is
when
my
you
lord. Kindly see page 33. Page 33 is the Zamabandi, my lord. Original Zamabandi.
And page 32 is the operative portion of translated provision.
Mr. Pine, it's a old document, we are granting bail then. We'll hear it. And Mohammed A. Hussain, the counsel for the petitioner, also at transfer for the respondents. Pursuant to order dated 23/7/2025, from the records of the tribunal is received. To stop the learned counsel for the petitioner has paid for bail, comma, which is opposed by the learned standing counsel for the FT matters. Considering the projection made in this writ petition and considering the documents which are available in the TCR, the court is inclined to grant bail. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Which place?
Zaimel.
Ojai.
Yes. That's number
As far
5.
as the records are received, issue rule returnable forfeit without requiring any fresh steps to be taken. Next, release the matter for hearing in the week commencing 3/11/2025.
Obliged, my lord.
Yes, 42.
I'm sorry, my I was not there.
Okay.
It's a habeas corpus petition, my lord. Page 17, my lord.
What is the predicate offense for which you were arrested?
My lord,
NTPS.
my lord, this is the memorandum of arrest, my lord, page 17, my
Now, there's a recent judgment of the Supreme Court.
my lord.
You
My
don't
lord,
get the benefit now.
No, my lord. To be honest, my lord, fair enough, my lord. Lordship will see, my lord. Puran Shetty, Puran Shetty. Pranay Shetty's case, my lord. The constitutional bench, my lord. It says, my lord, the earlier judgment will prevail, my lord. And recently, my lord,
Chetty is
regarding MSCT case, madam.
regarding MSCT case.
MSCT. 23 criminal appeal number 234 of the 25.
So we
So
have
one-
it. We know that.
My lord, one judgment of the coordinate bench, division bench, my lord. It criminal appeal number 234 of 25. Last Thursday, my lord. Criminal appeal. এখন সিআরপিসি May I please, Lordship, kindly have a look at the CRPC, my lord, 41B, my lord. That's it. Hmm? 41B, my lord, second part B, my lord. Every memorandum of arrest should be countersigned by, my lord, the family member or a respectable person of the locality, my lord. Yes. Now, if your lordship sees the memorandum of arrest, my lord, in the instant case, page 17, my lord, no witness, nothing, my lord. It took 68. Yeah, it's a lot of time. Paragraphs 15 and 16, ma'am. Yes.
Your Lordship, Mr. SCKL is not available today, so Your Lordship, a short date may be given.
Pardon me.
Your Lordship, Mr. SCKL is not available for the matter today, Your Lordship. A short date may be given, if possible.
Day after tomorrow.
Yes, Your Lordship.
One submission, my lord, for me, my lord, your lordship may record it, my lord, because, my lord, in the petition, my lord, one paragraph I have omitted, my lord. The petitioner approached this court for bail, my lord. That was rejected, my lord. That may be I'm fairly submitting, my lord, because that averment was not there, is not there.
Fourth, may I please, your lordship? 4th of August may be fixed, your lordship. 4th August, Monday, your lordship. Yeah. Oh,
August is
September, sorry.
September.
September.
You are traveling behind time.
Sorry.
You must watch Back to the Future.
So my submission, my lord, three part, my lord,
If it's
47.
available, then we take it up on Friday, the habeas corpus.
Yes, my lord.
Friday, your lordship, Mr. Ezekiel will be on leave. Monday may be fixed.
Monday.
Yes, your lord.
Okay.
Because they have not filed anything, my lord. And the High Court rule says, my lord, habeas corpus is returnable by 3 days, my lord.
This is item 42. But this time just the top at top. With the right reply. But Miss
P. Upadhyay, your lordship.
P. Upadhyay, not the getting of the airport. The SC cab for the NCP.
Yes, sir.
Praise for adjournment. As the learner standing for not available. Speak a habeas corpus matter or adjournment cannot be out. Based on 1/9/2025. Just
Madam-
remind us of your statement. We'll take note of that.
Yes, lordship fixing on
First.
1st September.
But in addition to that, my lord, that 41B, my lord, one more section is 60 capital A has to be.
60.
60 capital A of the CRPC, my lord.
Yes.
And no arrest shall be made except in accordance with the provision of this code or any other law for the time being enforced, providing the arrest. That
Time being item
I'm
46.
obliged.
But in this case, my lord, the matter is today posted for, my lord, the petition, my lord, interlocutory application number 1741 of 2025. It is filed for condonation of delay. There has been 2053 days delay in filing the present review application, my lord. On the other day, my lord, your lordship has called for the WPC number, my lord. Record of WPC number 3602 of 2019, whereby our petition filed against, my lord, the opinion dated 26/12/2018 in FT case number 279 of 2016 was dismissed. My lord, if you,
PC. Zero.
In fact, my lord, we are appearing as legal aid counsel in this case.
Yeah,
Delay is explained, my lord, in paragraph number 3 and 4 of our application, my lord, for condonation of delay at page 4, paragraph number 3 and 4. Bill. My lords, the petitioner was arrested on 19/12/2024 by the Superintendent of Police Border, my lord. And since then, he is put under detention camp, my lord, Matia Gwalpada. My lord, I am told that he is aged about 75 years. And my lord, there has been difficulties of our eyesight and also suffering from, my lord, the aged ailment, my lord. Lordships may condone the delay, my lord. My respectful submission, my lord. My lordship's consideration, my lord. Subject to your lordship's consideration, my lord. Your lordships may condone the delay, my lord. And my lord, the matter may be fixed for admission hearing, my lord, the review petition.
In 2000 days, we don't find the count. The reason.
My lord, when the petitioner was arrested, my lord, thereafter, my lord, they came to know regarding my lord, the order passed in the writ petition number, my lord, 3602 of 2019, my lord. The learned counsel appearing in the WPC, my lord, he did not inform the petitioner, my lord, regarding the dismissal of the petition. After she was arrested, my lord, he approached, my lord, the legal aid authority, district. Then district legal aid authority, my lord, forwarded her letter to the secretary legal aid, High Court legal aid authority, my lord. And accordingly, legal aid authority, my lord, I have annexed the letter, my lord, at page, your lordship will find. Annexure 1, page 8, my lord. Is a letter, my lord, dated 10/1/2025 after arrest, my lord. 29, he was arrested. Thereafter, my lord, she filed an application before the Secretary District Legal Services Authority, Gwalpada, and seeking her, my lord, legal aid. And thereafter, my lord, by the annexure 2, page 9, my lords. The letter, my lord, issued to us, my lord.
But sorry, 2000 days.
My lord.
Find any ground.
My lord, that was not, my lord, intentional, with all respect, my lord. And that was not deliberate, my lord. If it is, my lord, not within her knowledge, my lord.
No,
How
see,
could she,
we can't encourage that.
my
If
lord?
he is the petitioner,
It was her
It
duty
was
to
her
find out.
duty, correct, my lord. That I concede,
You
my lord,
can't
yes.
blame, you can't blame the lawyer
She,
not to inform.
my lord, she has to be busy.
No, we don't know. Very, what do you call it? Incidentally, we may tell you. Have you read the Wakalatnama? Let me ask you a question. Have you read the Wakalatnama?
My lord, yes, we have.
Yes. Does it contain anything that the advocate will inform the client?
That is what I am submitting, my lord. It was the duty of my
No,
client.
then we can't encourage that.
To my
It
lord,
may lead to filing of, after, if we allow this, after 20 years, somebody must come and say that I don't know.
to be vigilant, to be, my lord,
But
serious
see, we
enough,
can't have a standard.
my lord.
We can't have a standard that the advocate not informing, you can come after 2000 days. If you do so, tomorrow, if somebody comes after 10,000 days,
Your,
you can't stop him.
your lordships kindly appreciate, my lord. They are poor persons, laymen, my lord, illiterate, and my lord, cultivators, my lord, in fact. My lord,
Whatever
they
it
do
is,
not
Mr.
know about the, my lord, the proceedings of law, my lord. And these
can't-
orders, my lord, it was passed, my lord, as I have pointed out, my lord, 2019, my lord. But the arrest was taken place, my lord, in the year 2024.
We'll pass
And
strictures against the
after
police.
arrest, my lord, the things,
We'll pass strictures against the police for not arresting.
that is not required, my lord, because my lord, in fact, my lord, this is
No,
a
but
fact, my lord. This is, my lord, to be very honest, my lord, this is
No,
the
no,
fact,
we are not finding any fault with you, Mr. Sen.
my lord,
We are not for a moment saying that your statement we are not accepting.
my lord.
The extension of 2000 days delay. 2000 days delay would be 8 years, 7 years. Uh, no, 6 years. No, sorry. we can't control.
My lord, if your lordship may fix a date, my lord, let us have it in some other day, my lord, if I get some authority on this point, my lord,
No.
whether, my lord, whether on this count, my lord, the delay can be, my lord, condoned, my lord, under these
No.
facts and circumstances.
We have this depot cow. Heard Mr. B.K. Sen, Leonard, legal aid counsel for the petitioner, also heard. Okay, we did not hear you.
Lordship. I think Lordship, if there is some ground, Lordship, then question of delay arises. I have gone to the review this, Lordship. There is no ground at all, Lordship.
No, you are supporting him or supporting him or opposing him?
Opposing him.
Oh, then it's okay. Heard responsible for the respondents, next para. By filing this interlocutory application under Section 5 of the Limitation Act, the applicant, namely so-and-so, is praying for condoning the delay of 2053 days beyond the period of limitation in filing the connected review petition. Next para, the connected review petition is directed against the
Review petition is not yet registered total. Its filing number.
Order dated 7/8/2019 passed in WPC 3602 of 2019. Next para. The case of the applicant is that he was taken into custody by the police and lodged at the transit camp, Matia, Walpara. For which she could not file the review petition on time. Next para. It is also stated that the applicant was not aware about the legal remedies which was available to her, and that she could get legal assistance through the Legal Aid Council. And therefore, on coming to know about such legal assistance being available, I approached the District Legal Services Authority, Gwalpara District Legal Services Authority, and the said authority by a letter dated 10/1/2025 requested the Secretary, Legal High Court, Guwahati High Court Legal Services Committee provide legal aid, and accordingly, by a communication dated 24/2/2025, the Legal Aid Council was engaged for the matter. And some time was consumed by the Legal Aid Council to prepare the review petition and to present it before the court, by which time the delay of 2053 days, beyond the period of limitation, has occurred. Next, the Legal Aid Council has submitted that although the proceedings of the WPC 3602 of 2019 were disposed of by order dated 7/8/2019, but the result of the but this said order was not communicated to her by her then engaged learned counsel, and she became aware of the dismissal of the said writ petition only after 19/12/2024, when she was taken into custody. Next paragraph. The pair made in this interlocutory application is opposed by the Learned Standing Council for the FT matters. Next paragraph. In the considered opinion of the court, having preferred a writ petition against the opinion dated 26/12/2018, passed by the learned member from Foreigners Tribunal number first. There one SP here. One SP. Barbata in FT case number 279/16, arising out of IM within bracket D bracket post T case number 3074/97, whereby an opinion was expressed that the applicant is a foreigner of post 25/3/1971, it was the duty on part of the petitioner to, applicant, to keep a track of the proceedings which was preferred by her. First off, non-supply of the information about the result of the WBC 3602 of 2019 is not found to be a ground on which the delay of 2053 days could be condoned. Next para. Although the learned counsel for the applicant has submitted that the applicant has a good case on merit, but but that alone would not be a ground for condoning the delay in view of the nature of explanation tendered by the applicant, which is rejected. Next para, resultantly, this interlocutory application stands dismissed. Next para, resultantly, the unnumbered review petition filing number 4912/2025 stands dismissed.
My lord, petitioner may kindly be provided, my lord, the medical attention.
You
My lord.
apply, they have a hospital there. They have a full-fledged medical unit.
My lord.
If he has any difficulty, she can just go there.
My lord, I am told that she is not giving proper medical attention, my lord. That is why, my lord, some observation is required, my lord.
If you have any specific, you tell us that she has gone there and she is not been given the medical aid, then we'll take cognizance of it. That will be serious, but not without any statement. We'll have to rise. There is a second division bench.
My lord, item number 34. I am deeply obliged.
Because your lordship, there was a
Have the case record with you?
Yes.
Case diaries were returned to you.
Yes, yes, there is.
Yes.
Yes, yes, got it. But this matter is regarding lot we had heard in length earlier a lot. The matter pertains to a firing incident which happened in Dimahasao district, Maibang police, under Maibang police station, Maibang railway station in this before the Republic Day on 25th of January 2018. And wherein your lordship, there were shots were fired, your lordship, in the crowd. And around 12 persons were injured, out of which your lordship, two succumbed to their injury. Your lordship. So what has happened, your lordship? There are two factors, two sides to it. One, your lordship, is that there has been a substantial delay, your lordship, in the entire investigation process, your lordship. Nearly 8 years there has elapsed. And the second part, your lordship, is that lordship has found number of discrepancies in the entire investigation process. Lordship had gone through the case diary, your lordship, and lordship had observed that the case diary itself numbering was not done properly. There was no proper continuity. Second aspect, your lordship, was that the post-mortem report, your lordship. There were discrepancies in the post-mortem report. Initially, it was not available. Another aspect, your lordship, is that there was a carbon copy of the post-mortem report, and there was whether proper and thorough autopsy was done. That aspect was also your lordship has observed. Thereafter, your lordship, there was one aspect which was there, that was in regard to there was a letter from the DGP stating that to the IO that the final form should be submitted. And there is also a letter which has been submitted by the SP Dimahasa also, wherein he has written to the IO that the Honorable DGP has mentioned that your lordship, the investigation should be completed immediately. Lordship observed that there is a final form to submit final form. So on the last occasion, your lordship had wanted to know whether the DGP can direct the IO, your lordship, to submit the final form, your lordship. Whether it falls within the supervisory nature, your lordship, or whether in an investigation conducted by an IO, whether that will amount to going beyond the nature of supervisory.
We pose that question.
What if that question had emerged, your
We
lordship?
pose that question.
Your lordship had posed that question, your lordship. There was a question that DGP directs an FF when inquiry is going on.
No, because we don't remember that, because although it's 2 months, I may not be remembering it.
Yes.
But this question should not have been asked. The reason is that it falls within the domain of the supervisory jurisdiction. Because he will have to say that, please do it early.
Lordship. So, lordship will observe whether final form, to submit final form.
Final form is, it can be both ways.
Yes.
It can be by, what you call,
Yes.
implicating someone or exonerating someone.
Right.
Both are called final form.
Lordship.
There's no distinction in the nomenclature.
Yes. So only that aspect, your lordship.
Because if you pose that question, it was a wrong question.
That question had cropped up.
No, it's okay, maybe, but
yeah.
I don't think it is a correct question because in administrative circle, it is quite permissible to say that please do it early. An early investigation can be done. This is within their domain.
So there is a letter, if I may take your lordship to that letter.
That is at page 81.
The affidavit of respondent number 5, your lordship, SP Dinata.
Whatever is page 81, there is a letter.
Page last, annexure 1E. Yeah. This is from the SP Dimahasao, which mention of a letter of the DGP. Your lordship.
But you see, this starts with the statement.
Yes.
First 4 lines will read.
Yeah.
Dispose of all cases registered prior to 31/12/21 within August 2024.
Lordship. And
So,
5.
so that is the decision taken in the crime conference.
This is what they have referred, and there is one letter your lordship had referred from the case diary, your lordship, where the DGP had mentioned. Both meaning included finding against the accused or final report. So that observation was there. To that aspect, your lordship had asked the state whether what is their submission in that regard.
What is the status of investigation now? What is the status of investigation now?
Yeah, the case that is we have. In fact, the updated diary, on 5/6/2025,
It's, after the last order, this was not sent to the IO.
But
because you see, if the case diary is lying here, definitely there will be no progress in the investigation.
it was received in the month of June. And
it was listed in June, and thereafter we sent it back to be sent and reproduced on 24/6. 10/6 we passed the order, giving you the case diary, asking you to produce it again on 24/6.
The case diary was circulated by
yeah,
So then there will be no progress, and we'll have to then send it to the external agencies for investigation.
well, the officers were called, well, they came and along with the
Huh? But you see, unless something is done very early. You see, there is an order of the CGM of 12/9/2023 that the investigation will be taken up for early disposal. This is that order in this diary. This is the order. You'll
Yes.
flag it. Now, after that, the authorities write for early investigation. We don't know of the status of the IO at present. This was, my brother remembers that it was to one Gaurav Agarwal. But we don't know whether he's still the IO in this case or not.
He's not there. Now that is not the MyBank PS2, Malak. And this is MyBank PS6. In
Because
six,
if
Malak,
there's no progress, then we'll have to give it to some other agency.
no, there is progress, Malak. That is why Malak, I have flag marked the last up-to-date thing. They had said that the investigation that particular flag mark last the second last page of the case diary. I'll see that. He has almost completed the investigation and
There are two cases.
two cases. One is MyBank PS2 of and that is MyBank PS2 of 18,
Another is fake.
and this is 6 of 18.
The IOs are both same, your.
No, IOs are different. Different.
Jayanta Borua was there, additional SP fine.
He is no longer there. He is no longer. Subsequently here, Shamsul Islam is Shamsul Islam, and other is Malad in MyBank PS2 of 2018. Mr. Raju Gogoi, he is the IO, and Shamsul Islam is IO in 6 of 18.
No, we don't know that whether they are not taking it in right earnest or there's something lacking. If in cases like this, if the records are called for by the court, they have to open up a supplementary and then send it. They could have sent a scan copy.
In fact, Malad, I have communicated them, Malad, on 18/6 after the honorable court order, Malad, we have communicated that indicating that on 24/6 cases before hearing, and I have also Malad, I called them, both the officers came, Malad, because on last occasion, Lordship has indicated some paginations were not there, and some pages are Malad, not arranged properly. So both of them were called. And I have talked to them, and I also suggested them to proceed, Malad. The diaries are here because matter is in session, Malad. But they were suggested, advised, Malad, from our side, Malad, that to go ahead with the copies, Malad. Malad, I'll just because my letters are there, I have not received.
You see from the records here,
Malad.
What you call the postmortem reports were not collected.
The reports are there, Malad, that we have explained. One query Lordship has, Malad, Lordship had at one during the course of hearing. The one slip Lordship has indicated that the IO has said that from GNRC he has collected. That was subsequently clarified because all the papers are in the case diary. The Bhangaghar police has collected it from the collected it, Malad. That GNRC was wrongly signed. Those documents are there. I have indicated. Body, he died at GNRC. From GNRC, police took him to GMCH. Postmortem was done, and again, and the report was subsequently collected. It is the records are there. Malad, the latest position I will take up. I'll take, Malad.
Only people that died,
Lordship, two persons have died.
two persons have died.
Yes.
The inquest report is not there. Inquest report is not there. Yep. What about anything? No, the hospital. There's one person who died. His name is Plavanto Amusa.
Proben Patmota. Yes, sir.
One died at
One-
Pravanta.
Yes, yes. One
Banta.
Proben Patmosa
Atmosa.
Yes, your lordship. But PM examination was in GMCH. And another is Mithun Dibregede, who was referred to GMCA, but he succumbed to his injury in near Lamdi on the same day.
BP, Nagaon Civil Hospital, his PM was done.
One is Mithun.
One is Mithun.
Yes.
Mithun, his postmortem was done at Nagaon, BP Soliha Civil Hospital, Nagaon. That is the original PM report. In the second case that Lottie will find. And in respect of the second person, that is the carbon copy of the postmortem report.
Lordship had posed that question, your lordship, in regard to the carbon copy.
Along with, after the postmortem report, all the documents are there, how the police has collected the copy from the GMC.
Don't have. You see, we have no choice but to ask you that within, say, Monday next, you inform us the timeline within which you will complete the investigation. Otherwise, we'll have to, if we don't see a reasonable timeline, complete the investigation because this petition is pending here since 2018.
18.
If we don't have a definite timeline, then we are bound to give it to some other external agency to do the investigation.
Lot. I'll apply to that. Lot.
We are listing the matter on, you get the information by first, we'll having listed it on second.
Lot.
Because in, this will take some time to hear, to look at it lot completely. And, Mr. Rajpa, the points of argument you'll have to please pen down.
Lordship, I.
So this is not a regular bench, we may not be
Yeah.
assembling regularly. Maybe every time we look into it, we may have different ideas. But what we were searching for and we are not getting it, number one, the details of the persons who were detailed during that time. We don't have the armory report as to how many bullets were fired, or there's no certainty with regard to the amount of bullets fired.
Yes.
Then the in this, we will send it to you. There's a sketch map which we have flagged. In this sketch map, we don't see the place from which the firing took place.
Look, in Lordship's record, my lord, some photographs are available. We have handed over the photo.
No, that photograph is of the this there only, that file only.
My lord.
Those are the photographs of the protest being going on in the protest police station. It's not a photograph of firing.
No, with the train also, because the protest.
So we understand, but where is the location of firing? For that we have to look. You see the flag.
I'll
First few flags is the map. Some yellowish flag.
Yeah.
You got it? After about 10 to 20 pages. No, not that below. Not so below.
This way, correct?
No, in the sketch map.
Sketch map, yeah.
Not, there's a flag put down.
Yes. This one.
Yes. The bigger one is there. In the other file which you gave. You see, in this file, the place of firing is not mentioned specifically. So we'll have to assume from this this sketch map that there's a train which is shown as standard train. Then there's a platform. We have to presume that it is in the platform, and the site, the place where the people were standing, we were not aware. My esteemed brother has also was reading the other case diary. You are trying to project that the the train fuel tank was leaked and then there was thought to be put on fire. but the actual damage assessment of the train, that we are not finding. So there must be some nexus with the, you see, merely by saying that somebody was trying to damage it and then we shot at them. There must also be a corresponding document to show that there was in fact any damage done to the train. That's one part. Second part is with regard to the petitioner, that maybe he's a protester, maybe he's in the mob. But the use of force is excessive and therefore his case is only compensation. Mr. Rajpai, I don't think would be more interested in finding out who did it, who was the culprit. Basically, he would, after this.
Nobody was individually targeted because there was a lot of huge gathering was there. They to control it was a control fire.
Because these are that when somebody, the family is died, there should be a adequate compensation paid within time. That is his first anxiety.
One-man committee, there is one committee, your lordship.
Yes.
They said the firing happened from the platform. So there they have stated, and that is why, your lordship, the bullets, it hit the person above, your lordship, mostly above the plate, your lordship. That is where they have been. And so what we are seeking, your lordship, is that we were seeking a fair investigation in it. Your lordship has seen that now 9th IO, your lordship, from what we have come to know. In fact, the status report itself was submitted almost same day last year, your lordship. And 8 years have passed, your lordship. And there are many discrepancies in the case diary itself, as lordship has highlighted here, from the inquest
We
report.
don't remember it. Once we don't pen it down, we don't remember.
I will submit the point, your lordship. I will, in a written form, your lordship. Because there was discontinuity in the case diary, your lordship. Then there was discrepancy in the postmortem report. In regard to the inquest report also, your lordship, there were 2 bullet wounds, but 1 was mentioned. There were, in regard to inquest report also, it doesn't show 2 wounds, only entry-exit wound is written, but no mention of the wound on the head. There was an injury on the head also in the inquest report. So I will bring it all those aspects, your lordship.
In the case diary, from page 263 onward, the photographs are there and the damage of the relay property is apparent. The
No, proximity caused us not that damage. The cause of that firing was that they were trying to burn the train.
yes, in fact, there is a photograph that suggests, right?
Destroying of the property was there, but
Yes.
that was, you see, Mr. Nath, let us say somebody is attacking a house. Correct. Somebody, we have seen that photograph. So don't send it.
Lot.
We've seen that.
Lot.
You see, somebody is attacking a house, and you are there in the vicinity protecting that house. Now, please tell us, where would you fire? You will be firing to the people who will be in the vicinity of the house. No, correct. Now, these people will assume for the timing that these people who have died were in the railway station, inside the railway station, damaging it. But then these people would have been shot in the inside the railway station precinct. Or if they were damaging it on the train, then only there is a possibility of you firing at the from the platform outside to towards the what you call railway line. People standing in the railway line.
Lot.
So we must first have a clarity as to this deceased people where they were.
They were ladies, women. One of the injured is also a lady, and there are minors also. And 800 passengers, your lordship, they were shifted without any injury, your lordship. And police, there is only 1 injury. 1 person was injured, and he was also released after treatment, your lordship. Whereas on the other side, your lordship, the excessive force, nearly 11 persons were injured due to 56 rounds. 56 rounds of automatic firing.
You see, 56 rounds for a police firing would not be too many because of the fact that we were exploring the possibility of going to the police range and see the firing. Because what we came to know is that once a trigger is pulled, maybe 20 rounds can go up together, and it will require very trained hand in a what do you call this, the automatic rifle to shoot out one bullet at a time.
One per
It will require great amount of practice. Otherwise, once the trigger is pulled, then barrage of
go
that can go out. So if there are many people standing and then firing take place, 56 rounds would be nothing. But that's not the point. The point is that whether it's an excessive use of force, how they have justified the excessive use of force.
from the
That document we are not getting.
from the record, Malak, whatever is available in.
And another
That's we are
aspect,
not the these
Yes,
are the
yes.
things which we for the time being require.
Yes, yes.
You have used force. How did you explain it to your authorities that why the excessive use of force?
Lordship.
and another aspect, Your Lordship, is that a burn call was to end at 5 p.m. And the incident happened around 2 p.m. Your Lord.
No, it went
Whether the
violent.
administration could have waited for 3 hours, Your Lordship, because in other
Unless
cases
we
there
see
has
the
been.
record, we can't jump into a conclusion.
It went violent, Malak. The amount of stone pelted, those are available on record, Malak.
No, we don't know. That's why we are not
Look,
commenting.
photographs are there.
Once we
Photographs
have
are
a
there.
clear idea of what has happened, then
Lordship. If 400, 500 people, the pelting of stones are available in the railway track, stones are available, unlimited stones. Pelting of stones, just.
we don't know. We can't jump into a conclusion. Let the
True, true. From
examination
the
be
record.
brought on record.
No, look.
These police people were there. How their examination are there? What statement they have given?
Their statements are there.
How they've justified the action and how the authorities have taken it about the use of force.
Malak.
Just make that note.
Lordship.
The incident happened when?
Happened on 25th January 2018, Your Lord.
Mr. V. Rajput and a counsel for the petitioner, as well as Mr. Dean Nath, and the senior government advocate, along with Mr. N. Karita. You are APP or the government advocate?
Panel advocate.
The government advocate present. Next paragraph. The incident of police firing took place on 25/1/2018. Until date, the investigation of the case is pending and not brought to its logical conclusion. Despite communication by the Superintendent of Police based on the instructions from the GP to complete the investigation within in a time-bound manner. Accordingly, in the interest of an early investigation,
the court is inclined to direct the learned senior government advocate to have a scanned copy of the case diary made, scan of the photocopy of the case diary made, and the original case diary be returned forthwith to the investigating officer. Next paragraph. We also direct the learned senior government advocate to have a consultation with the competent and responsible authorities in the Assam police to inform the court as to the tentative time that may further be required for completion of the investigation. Next paragraph. If a reasonable timeline is not provided, court would be compelled to pass an appropriate orders on the next date of listening. Next paragraph. The learned senior government advocate shall send a downloaded copy of this docket to the competent authority to obtain instructions, preferably within 1/9/2025. Next paragraph, list on 2/9/2025. Preferably at 3:30 p.m. Just make a note so that
Lot.
it's easier for us to.
Lot.
Right, because
I'll make a
it's
little
regular
suggestion.
bench, we can't sit regularly.
Lot.
So again, it will be spilled over some days. And you also, any point you would highlight, please have it done.
Lot.
If there is, we are returning to you.
Malot.
Can have a scan and send.
Yes, yes, I'll keep it then. Lot.
And that, the map is a big one. If you can't make that photocopy, have this smaller one you had.
Lot.
So Hazarika is always typically here. They had it.
So,
People makes.
October.